Mōrena tātou katoa, ki ngā tangata whenua, ngā manuhiri tuarangi kua taim mai nei mō tēnei kaupapa. Ngā hau e whā, tōku whanaunga, tēnā koe hirani. Ngā hau e whā, ngau mai haere mai ki tēnei kaupapa nui. Ko kai ata whetū te maunga, ko waimamaku te awa. Ko kura haupo te waka, ko ngāpuhi te iwi, ko te roro o te hapu, ko Khylee Quince tōku ingoa. Good morning and warm greetings everyone. As I've just said and as I've been introduced, my name is Khylee and I am from the mighty iwi of Ngāpuhi and Ngāti Porou, two of not only the two biggest iwi Māori in the country, but two of the prime areas, Te Taitokerau and Tairāwhiti, of dope growing, smoking, dealing in our motu. So and I'm really dying to have a tutu with this to see if I can get the pointer to go. Which one do I use for the wrong one? Not that one. Which one does the... Oh, there we go, just so I can show you the most beautiful harbour in the North Island. So as I've said, my name is Khylee, and so my personal life is, so this is me, and in my professional life I am the Associate Dean Māori, the Tumuaki Māori at the University of Auckland Faculty of Law, where I teach mainly criminal and youth justice focused courses. And prior to that, I practiced criminal and family law, mainly in Central Auckland and South Auckland. So in that life also I had quite a lot of dealing with, not dealing with clients who obviously were chronic users and abusers of cannabis. I have no really relationship with cannabis personally. My only unhealthy addictions are the Warriors, buying shoes, and Facebook. But I do, however, I have a brother-in-law who was detained as a special patient for a homicide he committed while in a drug-induced psychotic state, and I have many cousins who are living with chronic cannabis use every day. I also have a brother who was quite annoyed at me for not coming here to give a strong legalisation talk, so we still love each other, so we'll have to make up after today. I really want to make four short points in my talk, and I'll talk more to it in our panel discussion. But I'm talking as a lawyer, of course, and I wish I was as artistic and good with words as our speakers yesterday, particularly. And I did want to acknowledge and say that I appreciated particularly hearing Rio and Lani's stories yesterday. So ngā mihi aroha ki a kaurua for sharing your experiences with us. But so I've got narrow little lawyer brain on, and these are the 4 points I want to make today. So one, I want to talk about how the law, very quickly, as it is applied and enforced, has a discriminatory impact upon Māori individuals and Māori communities. And what does that mean for us? In legal terms, that means that this is a breach of a lot of different domestic and international laws. So civil rights law, human rights law, both in New Zealand and in terms of international law instruments, and also a breach of the Treaty of Waitangi. So it's a breach of particularly Article 3, the promise of equality, of the promise to treat Māori as equal citizens of Aotearoa than non-Māori. In a broader sense, I also want to talk about how that issue is important, not just to Māori in terms of the breach of our rights, but it's important to all New Zealanders because it reinforces our social exclusion and marginalisation. So in terms of the wider impact, I want to talk a little bit about how it means that a lot of Māori are submerged citizens. In terms of the growing gap, in terms of inequality between Māori and non-Māori, they are living submerged lives, an illegitimate economy. They are, our capabilities are being denied. So what Paula talked about yesterday is the realisation of our tapu, the realisation of our potential. And fourthly, I want to talk about, just introduce the idea, well, what can the law do? So I'm really going to talk about how the law is largely ineffective. That's a common theme amongst all of our korero so far. So what can the law do? Traditionally, the criminal law, and I'm a criminal lawyer, traditionally the criminal law is not meant to fix problems. It's not even really meant to address problems. It's just meant to criminalise, convict, and punish. That's the role of the criminal law. And punishment, of course, is quite different from treatment or problem solving. So I'll just introduce a segue into Judge McMeekin's korero coming up later today about the idea of the law and lawyers being agents of social change. How can the law assist in addressing some, relieving some of these problems? So I don't really want to go into the details of the stats in discrimination. Those are quite clearly known by particularly studies done by Professor Ferguson and others, as well as the Ministry of Justice and police data that's collated every year confirms this long-term discriminatory policing of the Misuse of Drugs Act against Māori. The first point to make is that the law itself is not discriminatory. The law itself is racially, ethnically, class, age neutral. That's very common. So it's the way that the law is applied and enforced. That is the way in which it is discriminatory. It's discriminatory in a number of ways. One is the focus on enforcing the possessory offences as opposed to the bigger offences of manufacturing, dealing. So it's the personal use and possession offences where Māori are particularly discriminated against. There are also questions of policing in terms of who is, the racial profiling, age profiling, which Sasha will talk about. Who do police choose to stop, search, charge? Because criminal justice usually operates as a filtering out process. We often think about criminal justice as being the police stop you, charge you, you're off to court, there's a trial or some process, you're convicted and sentenced. But the vast majority, 90% of offending doesn't make it anywhere near court. Criminal justice generally operates as a process of filtering out. So it's a process of discretionary decision making at every step of that big process, from police to imprisonment. Māori do not gain the benefit of those discretionary processes. So we are sucked in or filtered in rather than filtered out. So in legal and criminological terms, we need to think about why is it that we are brought in when other people are pushed away from the process. So we know that, for example, approximately 5% on self-reported studies, approximately 5% of cannabis smokers are ever criminalised in the sense of having a formal legal process taken against them. But for Māori, that percentage is much higher. So again, that's that filtering in process. So as you see at the bottom of the slide there, 34%, so just over a third, and this is a long-term pattern, just over a third of all possessory offences in any given year are people who identify as Māori. So much more likely to be arrested, much more likely to be convicted and punished for cannabis offences than non-Māori in New Zealand. So that's our first observation. I don't have time to go into a lot of the explanations as to why is it then that we don't get the benefit of these discretionary processes, and it's very difficult to question discretion. It's much easier to look at something that's formally discriminatory, like a statute or a law or policy that specifically tells police or judges that they must discriminate against Māori. The law doesn't generally work like that in New Zealand. So if you're questioning discretionary processes, why did the police choose to stop that person? Why did they choose to search them? Why did they choose, when they found something, to bring them in rather than send them away with a warning? That's a much more insidious discriminatory dynamic or process. Why does that happen? There are some different sorts of explanations we can think about. One is this notion of intersectionality. So around the world, and New Zealand is no different from anywhere else, policing resources, money put into enforcement of laws tends to focus on deprived communities. So you have the intersection of these different variables of people's identity. So policing tends to happen, the focus is on socioeconomically deprived communities. Policing is more likely to be enforced against or focused on young people, which again Sasha will talk about, and class, so race, class, all of those things together. So if you have communities or groups of young brown people in certain communities, you're more likely to be under surveillance. You know, I mean, Operation 8 is the latest example of that. But you have this historical relationship between not just Māori and the law, but Māori and the Crown generally. So this is just one little, you know, microcosm of that bigger historical relationship. You can think about surveillance, and I was thinking about Parihaka yesterday when Pāra was talking. We could talk about Takaparawa, Motor Gardens, you know, Hiruharama. You know, this is a huge, this is like a tiny still shot in this epic film of discrimination and negative relationships between Māori and the police and the Crown and the law generally. So that notion of intersectionality. Police attitudes towards Māori, but also Māori attitudes towards the police. There are formal studies. There was a formal study carried out by Te Puni Kōkiri and mirrored by a study by the police in 1998, which is a bit old now, but I'm not sure that the attitudes have changed much. But there is a mutual mistrust between Māori and the police. So the police admit to using different policing attitudes, different police practices towards Māori. The language they use when talking to Māori people, young or old, is different. Their body language, they say they use different stances in the way that they interrelate with us. So that you end up with this sort of mutually reinforcing negative behaviours. And of course on our side we have people that have attitudes of being anti-Crown, anti-police. I was reminded yesterday of one of my 4-year-old nephews came to stay with me a couple of years ago, came down from Awanui, and we're driving through Mount Eden, which is, for those of you who aren't from Auckland, it's quite a fancy suburb, and we're driving in my car, and he sees a cop car coming, and he like gets down under the seat as quick as he could, and he goes, "Puri mana," and he gets down, and I said, "What are you doing?" And he goes, "Oh, it's the popo," and I said, "Oh," and he goes, "Auntie, do you have a warrant?" I said, "Yes, darling, I have a warrant." And he goes, "Oh man, what did you do?" It's like, not the warrant I was thinking of. So very strong intergenerational social learning, as Professor Ferguson was talking about, of, you know, our ongoing historical relationship between us, the law, and police and the Crown. The legal consequences of cannabis-related convictions, and I'm not even talking here about the consequences internally within Māori communities. I may talk about that in the panel discussion, but just in wider, you know, New Zealand society, the legal and collateral consequences of conviction. Obviously, conviction from a criminal law perspective is supposed to be a punishment in itself. It is supposed to carry a stigma, the denunciation of unacceptable behaviours. And already you have a disconnect there, not that many Māori don't agree with, you know. It's not seen as being particularly shameful, therefore there's no deterrent effect. It's no biggie to go to court. It's no biggie maybe even to go to the big house. So if that doesn't work, that's the basic premise of criminal law, is that people are supposed to believe in it, they're supposed to feel ashamed and denounced when they are a transgressor, and you know, and there's a process to move, you know, to reintegrate back into the community. And that's one disconnect, if you like. Punishment separate to conviction is also another step in criminal justice. But the collateral consequences, what happens to you after your conviction? As we all know, we know that there is basically exclusion, restriction, stigmatisation that comes about as a result of criminal conviction. And that is across a variety of areas of law, so employment, in terms of not just keeping a job, but finding a job. In immigration, travelling. I have numerous cousins who've been left behind in the Great Whānau migration to the Gold Coast because of historical cannabis-related convictions. I had one uncle who was deported because he had completely forgotten about, it was nearly a 30-year-old cannabis-related conviction. He gets to Brisbane, he hadn't declared this one conviction in his life, he'd forgotten all about it, they found out about it, and he was put on the next plane home. And then we have families who decide not to go to the mines or to the Gold Coast because one member will be left behind. So there's really wide community impacts on, as a result of cannabis-related convictions. In family law, particularly when you have broken families or split relationships, where you have a non-custodial parent who is applying for access to children. A cannabis-related conviction will, to some extent, either determine or at least restrict their ability to have unsupervised access. Very common family law problem. Welfare. As we know, the social welfare issues in relation to job seeking, you are required to live in areas where you are able to seek employment. That's quite difficult in Hokianga, that's quite difficult in Tiki. So if you've made a choice as a Māori person to live within your tribal territory that doesn't meet the social welfare job seeker criteria, then you need to support yourself and your family in some way. And some of my relations say that's their justification for growing dope, selling dope in the community. It's not an excuse necessarily, but it's an explanation. So the social welfare policies are marginalising those people to make restricted choices. And I'm really talking about what Māori psychiatrist Mason Jury refers to as trapped lifestyles. You get in this cycle of negative reinforcement of the way that you live your lives. Why should all New Zealanders be concerned about this dynamic? As I've already mentioned, any bias in the law challenges the rule of law. So the basic premise of the rule of law in Western legal systems is this idea of law that is applied equally without fear or favour amongst citizens. So if we've got quite good hard data that shows that Māori are discriminated against unequally compared with non-Māori citizens of this country, you've got bias there. That breaches a whole lot of laws, as I've said. Internally, it breaches our Bill of Rights Act, it breaches the Human Rights Act, it breaches international legal instruments such as the Universal Declaration of Human Rights to be free from discrimination, numerous things at international law. And domestically, the other thing that sets us aside, we have a different relationship because, of course, of the Treaty of Waitangi. Now, I'm not sure if there are visitors here who aren't aware of the treaty, but very basically, the treaty is the blueprint for Māori Pākehā relationships in New Zealand. It's the founding document, really the founding document of the nation, and it's a negotiated contract in legal terms between over 500 rangatira, the community representatives of various Māori hapu around the country. And of course, the nice synergy for this forum is that also every Māori and Stoner will tell you, the first signing on February the 6th, 1840. What else happened on February the 6th? Uncle Bob's birthday. But the basic three promises of the treaty are cession of kawanatanga, of governance of the Pākehā people who emigrated to this country. And in Article 2, we've usually focused on the promise of Article 2, which is tino rangatiratanga, absolute chieftainship over our own taonga, physical resources, and ourselves. The recognition of who we are, the way we think, our way of being. But it's Article 3, which is the basic promise of equality of citizenship, that's breached by this sort of process, because it's my friend and colleague Tracy McIntosh, who's a Māori criminologist, refers to this idea of submerged citizenship, that the growth in the gap between rich and poor and the gap between Māori and non-Māori results in this submerged citizenship. This is the effect of the breach of Article 3 of the treaty, so that we have many people living lives of restricted opportunities, the normalisation of negative outcome pathways. I have another 11-year-old nephew who I had to explain last summer. He lives in Hokianga, and he asked me, "Auntie, why do you only ever come here at either when someone dies or Christmas and Easter?" And I said, "Because that's when my holidays are." And he said, "Holidays from what?" I said, "Holidays from my job." And he said, "Well, what does that mean?" And he lives with 3 generations, his mum, my cousin, auntie, and great-grandmother, none of whom he's ever seen in paid employment. Many of whom are daily users of cannabis, but they live a life that, to him, my middle-class urban lifestyle is completely alien to him. I had to explain that there are different jobs and that you get paid differently for different jobs. This was all complete news to him, an absolute epiphany. You should not have to explain those things to an 11-year-old boy. That's part of, and I could place that in this context of submerged citizenship, this normalisation, not necessarily of negative outcome pathways, but ways that restrict or constrain those people's choices in lives. And again, to put it in the treaty context, it's the difference between a chosen separate identity, which is the Article 2 promise, tino rangatiratanga, the right for us to be who we are in the way that we are with our tikanga, according to kaupapa Māori. That's a chosen, politicised, marginalised identity. It can be marginalised. But the Article 3 sort of marginalisation is that sort of separate identity that's forced upon us because of social, political, economic factors. That's not a real choice. So there's the capability deprivation that we should be concerned about. I probably need to hurry up. So the role of law, what can the law do? So far I've talked about the law quite negatively, but the law is quite limited. The law traditionally isn't meant to solve problems, it's not solution focused. Criminal law is all about punishment. You cannot do this. Criminal law does not do that, you should do this, or this is the way you should be. It just imposes punishment for things where there's supposed to be consensus about notions of harm or wrongfulness. So the role of the law traditionally is very narrow. So what can the law do? Yes, decriminalisation and legalisation of cannabis would address that immediate issue of discrimination, because if cannabis was lawful, or possession of cannabis, personal use was lawful, then the police would not have to enforce that. From a Māori perspective, that's only one of the sorts of offences, though, that we are over-criminalised for, or where there is discriminatory policing, but it would obviously change legal outcomes and consequences in relation to one sort of offence. As both Professor Hall and Professor Ferguson have talked about, we need, though, to open the political and legal conversation and process to take account of new evidence, new research, so that we're not looking at this forced policy choice between strict legalisation or criminalisation or maintenance of the status quo. To some extent, we have moved in the past 10 years. So we have the bill introduced, of course, or the act introduced by former Green MP Nandor Tanchos, which is the Criminal Records Clean Slate Act. That, of course, does suppress the criminal record of some offenders in New Zealand. Again, that's only if you have been clean or not been caught for 7 years. And doesn't apply in certain employment situations, doesn't apply in immigration situations, but it does generally help in relation to minor offenders in low-level offending. The bigger question and the segue into the next session is that there has been a complete mind shift in relation to the role of law with the introduction of what's known as therapeutic jurisprudence. So the use of the law, legal processes and legal agents as a means of social change. So focusing on problem solving or solution focus. So this is the problem-solving courts or solution-focused courts, such as the Alcohol and Drug Treatment Court. So there's a pilot in Auckland. And the Youth Drug Court in Christchurch. These are using the law, so quite a game changer, using the law to actually identify and solve problems. So my only observation and my concluding point is I'm sceptical of the role and place so far for tikanga and kaupapa Māori in those solution-focused courts. I think there needs to be a stronger conversation between Māori and the whole point of solution-focused processes is to be interdisciplinary. Those disciplines need to include Māori so that we can talk about the wider impacts of alcohol and drug-related problems or harms within Māori whānau and community. So, so that our goal, of course, as mentioned by others, is that we realise our true potential, so that we can embrace and retain our unique identity as Māori. Kia ora, I've finished.